Good morning and welcome to this December session of the Tennessee Court of Criminal Appeals. These are Zoom arguments. It's the second one of the day. It's being streamed over the internet on YouTube. You can receive this by visiting the TN Courts channel on YouTube. We wish to thank the lawyers appearing today and their willingness to use this technology. We thank Jim Hivner and his staff and the staff of the LC for making all of this possible. We would prefer to have in-person hearings, but in our attempt to help be part of a solution in stopping the spread of COVID, we are trying to use technology to help minimize the spread. And also, it helps us keep our case moving in a timely fashion. The judges appearing with me today are Judge Ross Dyer from Memphis, Shelby County, Tennessee, and Judge Camille McMullen from Memphis, Shelby County, Tennessee. I'm presiding Judge John Everett Williams from Huntingdon, Carroll County, Tennessee, and we are delighted to be here with you today. The cases that will proceed today are just like the same as they would be done in person. Each side is given 20 minutes to address the court. The appellant may reserve rebuttal time. If they would do so, we would ask that you do so upon approaching or not approaching the whale, I'm sorry, upon introducing yourself to the court. And I will try to help keep your time and tell you when you're getting into your rebuttal time. With that, Mr. Appellant, Madam Clerk, would you call the next case?
State of Tennessee versus Colton, Davon, Hatchett.
The appellant may proceed and your time starts now. Thank you.
Good morning, Your Honors. Todd Ridley on behalf of the appellant Colton Hatchett. If I could have 3 minutes for rebuttal.
Yes, sir.
Okay. Your Honor, today we're here to talk about two different issues related to Mr. Hatchett's convictions for the sale of methamphetamine in Henderson County, Tennessee. First, I'd like to talk about the sufficiency of the evidence. In short, the state presented scant evidence to establish the convictions for the sale of methamphetamine. In fact, if you look at the record, you'll find that all of the state's evidence regarding this conviction can be found on a mere 4 pages of transcript and a very short video with frequently inaudible conversation between Mr. Hatchett, an unidentified neighbor or female in the trailer, and a confidential informant that the state was relying on. So here is, in a nutshell, is what the proof in general appeared to show. The confidential informant made a phone call to an unidentified female to arrange the purchase of methamphetamine. Confidential informant, then accompanied by law enforcement, goes to a trailer, and can all be seen on the video, which I believe is just a video equipment that was placed on the CI when he approached the trailer. He goes into a trailer, has a frequently inaudible conversation with Mr. Hatchett and the female. He gives Mr. Hatchett money, then he exits the trailer. At a certain point, probably a few minutes later, Mr. Hatchett exits the trailer. It appears they have a little bit more conversation. The CI then leaves, goes and meets law enforcement where he's found to have methamphetamine. That is simply not enough to show a bargain for acceptance that is necessary to establish the sale of methamphetamine.
Let me ask you this. So let me make sure I understand the facts. So prior to going to the trailer, he is searched, his vehicle is searched, he doesn't have any drugs on him. Is that correct?
He's not in a vehicle. He's with law enforcement. So okay. I think it's just this person that's searched.
So this person is searched. He has no drugs on him. All he has is the cash that law enforcement has given him.
Correct.
He has a conversation with the defendant, has a conversation with the defendant, and this unidentified woman has an interaction with the defendant. He leaves, and when he's searched again by law enforcement, he has only drugs on him and no cash, and he testified, the defendant gave me the drugs. How is that not sufficient? I mean, how can a jury not look at that and go, that's enough?
I certainly think if the CI had testified that he gave me the drugs, that would be sufficient. But that's not what happened. What happened was the CI testified, I go outside and then I pick up drugs from the from outside the trailer, from the ground. At no point did the CI say, Mr. Hatchett handed me the drugs. In fact, he testified the opposite. He did not say at all that Mr. Hatchett handled the drugs, and the video doesn't show that. So if your honors...
I'm sorry, I thought, and maybe I just misread the briefs. I would agree with you. There's no testimony, at least my understanding of the briefs, that he actually handed it to him. I thought what the facts were was that when he came out the second time, he being the defendant, he dropped something on the ground. CI picked it up, and that's what the drugs were. While he may not have actually handed it to him, the testimony was he dropped something on the ground, and that was the drugs. Is that a fair assessment?
That is not my assessment of the record.
Okay.
My assessment of the record is that for whatever reason, and I think the state might have meant to ask that, did you see Mr. Hatchett drop something outside of the trailer? But I don't think that question was asked. I think what it shows instead is the CI simply picked something off the ground, or the CI said he picked something off the ground and returns to the trailer. I think if the state had followed up with the CI and asked him more questions about, did you see Mr. Hatchett drop the methamphetamine on the ground? That would be something that would more strongly suggest, at least circumstantially, the bargain for sale and delivery. But right now, what we have is just, you're asking the jury to make a huge inference that, well, that must have clearly come from Mr. Hatchett, despite the fact that there's another person inside the trailer who just as easily could have placed the drugs there. So that's the problem with the case. And one of the things I was thinking about when I was preparing for this was when I was a brand new lawyer, I was taking a default judgment and doing a hearing on damages. And I go through my proof with my client. And then at the end of it, the judge calls me up and says, I didn't hear anything about pain and suffering. Do you want to maybe make a motion to reopen the proof? And I said, well, of course, Your Honor, I'd love to do that. And I went back and made that motion, asked the client about pain and suffering, and then he granted me the judgment that I asked for. What happened here is that they needed to ask one more question. The state needed to ask one more question. And what the judge did for me in that case maybe should have happened in this case, that somebody could have stepped in and said, you need to follow up with this and make sure that all the I's are dotted and the T's are crossed. But right now we have this yawning gap between what you're trying to prove and what you've actually proved. And what we're asking this court to do is say, there is a standard. There is something that the state must prove when it's going to try to prove sale and delivery. And it just didn't get there in this case.
Let me ask you one more question on this.
Sure.
With the phone call that was made, was it in that phone call, or do we know, look, I'm calling to get defendant to buy drugs from the defendant, or did he just call this unidentified woman and say, I'm looking to buy drugs? I mean, so was it clear in the phone call who he was buying the drugs from, so to speak? Does that make sense, what I'm asking you?
I understand the question. I don't think it's clear in the record, and I don't think it's clear in the proof. And again, I think that's the fault of the state for not fleshing all of this out when it was presenting its proof. And I think what happened here is that you'll notice when you get into the record that a large part of the transcript is devoted to a second set of transactions that Mr. Hatchett was ultimately acquitted of. And I think kind of the focus of the trial wound up being about that second set of transactions. So this first set, or this first alleged transaction, was just very perfunctory. It's just this video and a brief recitation of what the CI believed happened. And it did not include, I'm going to buy drugs from Mr. Hatchett, I think. And we don't have a recording of the phone conversation, but what we have is the CI is planning on buying drugs. Now, it's clear when you watch the video, and especially the interaction between the CI and law enforcement, that law enforcement intended for the CI to buy the drugs from Mr. Hatchett. But that just makes clear what law enforcement wanted to accomplish. It doesn't make clear what the state actually proved about this transaction. So in short, I guess I would say that I understand what the standard review is for sufficiency. I understand that circumstantial evidence is certainly going to be construed in the light most favorable to the state. And there certainly is a fair amount of circumstantial evidence in this case. But there's one leg missing, and that missing leg has to matter. At a certain point, the purpose of a reviewing court is to hold the state to its burden and make sure that they dot their I's and cross their T's. And the fact that they didn't ask that essential question and didn't get that essential bit of testimony is fatal to the ultimate conviction in this case.
What is your quintessential question then?
How did the drugs come to be on the ground, Mr. Confidential Informant? And if the
what if the confidential informant said, I just took them off the table when I left. He took the $100. I know how much I bought. I just picked it up and left. He didn't tell me which package to get.
That would be fantastic testimony for the state. If he said, I picked up the drugs from inside the house at the same time that I exchanged the money, and that it was clearly understood between me and Mr. Hatchett that I'm buying drugs. But the question you just asked contained what the testimony maybe should have been, but they didn't elicit that.
In this case, did the CI go in the house?
He did go inside the trailer, and you can see that interaction in the video. The state had an easier time understanding part of the conversation than I did. I frankly couldn't understand any of it, but you can hear a little bit of a conversation. But I don't think you can hear at any point drugs being referenced explicitly, at least.
Okay, but he goes in with money, comes out with no money, but comes back with drugs. Is wherever he picked it up or how he got it, is that a major consequence here?
Sure, it certainly is. I think it is important, especially when you have the presence of other unknown or at least semi-unknown parties, where the CI is calling up somebody else to arrange for this transaction. There's somebody else in the trailer, and that his only interaction with Mr. Hatchett is an largely inaudible conversation, and the admitted testimony that, yes, he did hand Mr. Hatchett money. But we don't have anything that would indicate a bargain, sale for, and exchange. It's all implicit. And I think if the state had wanted to rely on that, it needed to elicit more testimony from the CI about what exactly was discussed, where the drugs were, how they came to be there. And if the CI didn't know, he didn't know. But at the very least, he could have said, or the state could have elicited testimony about that, and certainly could have filled in some of the blanks that Your Honor is asking about. The state didn't do that. And that is the problem that the state has with the sufficiency of the evidence. Okay. But if there are no further questions about that, I'll turn to the question of consecutive sentencing. And we are challenging sentencing on the limited point of the consecutive nature. So at the conclusion of, or after the sentencing hearing, the trial court imposed a 15-year sentence as a range 2 offender. It did so the range would have been 12 to 20, so it went a little bit up in the range to get to the 15 years. Then it stacked an additional 6-year sentence on that. The problem with the stacking of the 2 sentences is twofold. First, the trial court erred when it found that Mr. Hatchett had an extensive criminal history. Second, and I think probably more importantly, the trial court conducted essentially zero analysis of the essential question of, is the total offense commensurate with the offense committed?
Let me ask you this, because I was confused in reading the brief. So he's got the sentence in the drug case, and then there's apparently an aggravated assault case out there. Was he sentenced for both? Was this a joint sentencing hearing on both the drugs and the aggravated assault, or was he on bond for the assault case when he committed the drug offense? I'm a little confused at the timing of the 2 offenses.
As was I, and as is the record, quite frankly. I think what you'll see is there's very little information about that 6-year sentence in the record. He was not, I do not believe, on bond, because that was not the basis for consecutive sentencing. Had he been on bond, then we're not here on that issue, but I think it likely would have been mandatory. So what the trial court's rationale for imposing consecutive sentencing was a finding that he had an extensive criminal record. It was not a finding that, well, he's on bond, so it's a mandatory.
Well, and that's one of the reasons I asked the question, though. Even though the trial court didn't find it, he's got this 6 years hanging out there. He's either supposed to be, very simplistically, he either should be incarcerated on those 6 years, or he's on some sort of release on those 6 years. And that's what I'm trying to figure out is, even if the trial court's wrong, and I'm not saying the trial court was wrong on extensive criminal history, but even if he was, the bond issue, as you said, kind of eliminates the argument.
I think for the court to reach that, it would have to remand. It would have to find an error, maybe an error in that there's a lack of a record on it, because that was not the basis of the trial court's ruling. And I think it would need to go back for more exploration of the nature of that 6-year sentence. Because quite frankly, I did not or could not glean from what little was in the record, especially in relation to the sentencing hearing, what exactly that 6-year sentence entailed and what the basis for, or why it was still kind of hanging out there. Because again, if he had been on bond and you were stacking it for that reason, then I don't think we have an argument related to consecutive sentencing at least. But that, again, would just require more fleshing out in the trial court. So assuming for a second that the trial court's rationale was the sole basis for consecutive sentencing, and it's all we have, and that is extensive criminal record, and then the second aspect about, is this commensurate? So just taking that as a given, I'd start with the notion that this is not a case where there is a genuine extensive criminal record. You certainly have enough, and it was undisputed, you have enough of a criminal record to get him to range 2. But beyond that, you simply have a few driving offenses, marijuana conviction, and these assault convictions that were the primary basis to get him to the range 2 status.
Can I not impose consecutive sentences based solely on a misdemeanor criminal history, though?
You can. You can impose it solely on the basis of misdemeanors only, but there has to be some standard for saying, here's what an extensive criminal record here. In this case, it was purely conclusory. It was just, here's a list of convictions. That's an extensive criminal record. Now, when you peel that back, though, you see that these 2 assault convictions are from the same incident. You have some minor driving offenses and a marijuana offense. When you look at other cases from this court and from trial courts too, about what an extensive criminal record means, I don't think this should qualify. But that brings us to the more important question, and that is related to commensurability. Is a 21-year sentence for this offense justified? Now, it is imperative that the trial court conduct that analysis. One of the things that is a byproduct of Bies and Pollard is that we're going to give trial courts virtually unfettered discretion to impose whatever sentence they want, so long as they make the requisite findings and conduct the requisite analysis. That so long as is the problem in this case. The trial court made no finding that this was an appropriate sentence for the offense committed. Now, I've cited in the brief, and the state has argued a bit in the brief about the Biggs case, in which this court found in a reported decision that consecutive sentencing was unjustified because the total sentence was not commensurate. In that case, the trial judge actually did conduct an analysis and say, I think it's commensurate. And this court reversed, saying, we disagree, which is probably a little beyond generally what Bies and Pollard would call for. In this case, the trial judge didn't even do that. The trial judge just said, I'm imposing consecutive sentencing because he has an extensive criminal record, with no further analysis, with no further conclusion that a 21-year sentence for a nonviolent drug offense.
But he didn't sentence him to 21 years for a nonviolent drug offense. He sentenced him to 15 years for a nonviolent drug offense. And this is why I asked the question about the aggravated assault to begin with. Usually when a trial judge is running sentences consecutive, it's a group of things that occurred at the same time, or it's a series of thefts that, he committed over a period of time. And they're all kind of related somehow, and the trial court's looking at it that way. When they're running things consecutive, like a random aggravated assault that we don't really understand where it comes from, and then a little that's older, and a sentence like this, there's usually something like he was on bond or something like that. And that's why I'm confused a little bit by the record. And I understand you are too, Counselor. But it seems to me that he didn't impose a 21-year sentence. And so he imposed a 15-year sentence on this. And then, 2, the reason for stacking the aggravated assault and the drugs, it just doesn't flow in what normal how this normally happens, I guess is what I'm trying to say. I mean, and I'll go ahead and say to you, General, you can be prepared to answer this question as well. I mean, it seems to me it's remand, as you pointed out, Mr. Ridley, might be the way to go to try to figure out how you got these two things combined to begin with, because they're clearly from completely different instances and have nothing to do with one another at all.
Mr. Ridley, you're getting into your rebuttal time.
I'll just finish real quick with an answer to that question. And Your Honor, I think a remand actually might be what is appropriate in this case, given the lack of record. When you look at the sentencing hearing transcript, there's no evidence presented. It's just the pre-sentence report. The sentencing hearing transcript itself, I think, is about 15 pages long, with virtually no analysis and no real consideration of the kind of things that we're all kind of raising right now. And so if a remand is the way to fix that, I certainly think that would be appropriate and we wouldn't be opposed to that. But given the time, I'll save the remainder of my time for rebuttal. Thank you.
Thank you, General.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. Turning first to sufficiency, this is a relatively straightforward case, actually. I encourage this court to look at the roughly 7-minute video and compare it to the confidential informant's testimony as well as the officer's testimony. And you'll see, here's what the proof showed. That there was a phone call made, I believe it's to the neighbor. And to your point, Judge Dyer, whether he knew who he's buying it from, it's not explicit, but he does talk, the confidential informant testifies that he spoke to the defendant through the neighbor on that phone call. It's not entirely clear, but I think the jury can infer that
he spoke to the defendant through the neighbor. Is that what you just said?
Yes, Your Honor. He testified that I kind of just briefly spoke to him through a neighbor.
Okay.
So it's slightly unclear exactly what happened. But what is clear is he gets dropped off in a parking lot that's roughly 100 yards away from a trailer park. He walks up to this trailer, knocks on the door, and goes inside. There's an unidentified female and the defendant in the trailer. At that point, the defendant and the confidential informant go outside, and that's when the video indicates it's not clear. You can't see the hand-to-hand transaction, but it indicates that the confidential informant hands the defendant a $100 bill, and you can hear him say things along the lines of, "I don't care if it's short, and just eyeball it." And so while drugs weren't explicitly mentioned, Mr. Rainey the confidential informant was talking about how this was a drug buy. So then on the video, you can see the defendant go back inside the trailer with his hand in a ball, and the jury could infer that was holding the money. And then what you can see, the confidential informant waits around outside for 1 to 2 minutes, and you see the defendant come back outside and lean forward. You don't see what's in his hand, but you see him lean forward, and then less than 5 seconds later, you see the confidential informant walk forward and lean forward as if he were picking something up off the ground. And then he immediately walks back to this parking lot about 100 yards away, and a truck comes by with officers, and he gets in the truck with those officers. The confidential informant was directly asked about whether this was a hand-to-hand transaction, and he testified that it wasn't. He stated that he stated that they were on the steps. When the defendant came out, I picked the drugs up off of the steps. And so when you're looking at all of this in the totality, and again, as you pointed out, Judge Dyer, the defendant was searched before he bought anything. And all he had was this $100 bill that he got from the police officers. And when he came back, all he had was the drugs. And so, from that, any rational trier of fact could reasonably conclude that this was a very clear, blatant drug transaction. And really the evidence overwhelmingly supports the conviction for sale and delivery of methamphetamine. If the court doesn't have any questions on that, I'll turn over to the sentencing. And the first thing I want to point out is exactly what you pointed out, Judge Dyer. This is not a 21-year sentence for the sale or delivery of methamphetamine. This is a 21-year sentence, 15 of which are for the sale and delivery of methamphetamine, and 6 of which are for another offense, which is aggravated assault. And the proof at the sentencing hearing, though it was slightly unclear, does establish that this other offense is that the defendant was on probation for this aggravated assault at the time he committed the offense. And that's because the trial court, in making his enhancement and mitigation factors for the length of the sentence, not whether it was consecutive, specifically found that the defendant failed to comply or was on probation at the time this offense occurred. And that's on page 10 of the sentencing hearing. So that's why we have this consecutive nature. That's why they've kind of been combined, is because the defendant was on probation. I think we assume that he's going to be revoked on that. And the court said, well, when you combine these two, that's where you get to a 21-year sentence. Looking specifically at its findings for the consecutive nature, I think it's important. The court actually goes through a pretty lengthy analysis. It doesn't just say the magic words of the defendant has an extensive criminal history. Instead, the court goes through exactly what those offenses were, and in fact, when some of them occurred. Points out that the defendant had a conviction in 2016 when he was, that was a theft. He's got, this is quoting from the page 12 of the sentencing hearing, he's got stalking, aggravated assaults in 2016, more than one aggravated assault, driving offenses, public intoxication, other offenses going back to 2012. I find that in considering consecutive sentencing, the defendant is an offender who has an extensive record. The pre-sentence report established the defendant had 7 misdemeanor convictions and 3 felony convictions. So the court was clearly within its discretion to determine that extensive criminal history warranted consecutive sentencing. The defendant cites some other cases where this court has determined that's not necessary, that an extensive criminal history isn't established by the record. He cites to Hardy, and Hardy was where this court reversed when the defendant only had 3 offenses that were immediately in very close and tangential nature several years before the offense. And that's simply not the case here. And it's important to point out that even in Hardy, you yourself, Judge Williams, wrote a dissent that said trial courts are given this discretion, and these 3 offenses would establish a record of extensive criminal activity, and that the court was well within its discretion to order consecutive. So I think when you have that, and then you have the defendant's extensive criminal history here, the trial court was well within its discretion to determine that consecutive sentencing was necessary. If there are no further questions, state respectfully ask that this court affirm the judgments of the trial court.
I will ask you this, General. Given what the last argument that I heard from defense counsel, virtually, I think he's making an argument that at the end of the day, the judge knows the totality of what is done. And should he, at that time, knowing that it's 6 and 15, regardless of how it got there, 3 offenses or whatever, should he make a pronouncement, or she, on the record that I know the full extent of what I have done, and I think it is reasonable under these circumstances?
The state certainly wouldn't object to that. That would always be a nice bolster to the trial court's finding, but it's not necessary. It's not absolutely required in any way, shape, or form. Especially even at the very beginning, most trial courts establish that I have considered the purposes and principles of the sentencing. I realize that this is supposed to be commensurate not only with this offense, but if I run it consecutive, that it's supposed to be reasonably related to the offenses for which the defendant is serving his time. And so I think we can forego requiring the trial court to say very specific magic words about whether this is, an appropriate sentence, and just rely on the fact that trial courts exercise their discretion all the time and clearly don't intend to impose a sentence that is not appropriate. And so again, I don't think we need those magic words, or we have to have, those specific findings.
Thank you, General. My question calls any. Mr. Ridley, you're back up. 3 minutes.
I guess I'll just start where we just left off and say that it very much is required for the trial court to make the exact finding that Your Honor just suggested. It is required that the trial court at the end of its final ruling say, this total sentence is commensurate with the offenses that I'm sentencing the defendant for. If it doesn't do that, The problem is not a lack of a magic words. The problem is that it doesn't satisfy what Pollard and Buys are all about. What Pollard and Buys are about are saying, trial courts, we're giving you an extraordinary amount of discretion that we are not going to go in and interfere with your total sentence the way pre-Buys this court used to do, where it would say maybe knock an 18-year sentence down to a 15-year sentence. And the reason we're not going to do that is because if the trial court makes its findings, we're going to say it's not this court's place to come in and second guess that. But that is contingent upon the trial court making findings in the first place. If the trial court doesn't make any findings, it's not a lack of a magic words that's the problem. It's the lack of findings. You can't abuse your discretion if there's no evidence that discretion was ever exercised. And that's the problem we're having here, and problem we're having, I think, in trial courts in many cases. But what the trial court failed to do here was it failed to not just recite magic language. Trial court failed to make the essential findings that would justify consecutive sentencing. And at a certain point, appellate review of sentencing still exists. And it exists to ensure that trial courts make findings. If they don't make findings, the solution might not be to do the pre-Buys thing of just changing the sentence. It might be to remand. And obviously, for the reasons I discussed with Judge Dyer, that might be appropriate for other reasons in this case, but it is essential that findings be made. And the failure in this case is fatal to the trial court's decision to impose consecutive sentencing. And for that reason, we're asking this court to reverse the consecutive sentencing issue, assuming, again, that it survives sufficiency review. But if there are no further questions, again, we just ask the court to reverse.
Thank you for your presentations today. We'll take this case, as we do all, under advisement. And if there's anything further from the court, we will stand adjourned to the call of the third case today at 1 o'clock. Thank you.